Hi everybody, I'm going to try and do 9 for you today. Um, I'm going to talk more about legalese on this video. I was looking over all my notes and stuff, and I think I'm just going to do a little bit more jumping around than I originally intended. I'm going to get off my outline and talk more about legalese and handling court stuff. Uh, as I've already said in a lot of the earlier videos, legalese is just a slang term for law. Legalese, like Portuguese, Chinese, well, legalese. The attorneys have come up with their own language. Um, uh, so you have to hire them to translate it for you. And it's in its simplest term, on the simplest terms, mostly legalese is English and Latin. And as I said earlier on the last video, in law, it's important that you understand that in law, everything has a finite meaning. If you look up a word in a law dictionary, you'll see that it's not like regular language where you can have several different translations. In law, words have a specific meaning, and a lot of these words that we take for granted if you ever do have to go to court, or when you're reading a law, or if you're going to court on criminal or civil matters. A lot of times people will take for granted that they understand the information that's been given to them, and a lot of times that's not true. And so again, it's very important that you understand that if you exercise your rights, to have access to law information, whether you be incarcerated or not. Like, say you're incarcerated and you don't have any access to a law library, there's no way that you can look up to see what they're actually really charging you with. And if you don't know the law, you could be agreeing that you did something that, even though it appears on its face that that's what you did, but well, in a lot of cases, a lot of these offenses that people are being charged with actually really don't even charge an offense. I'm going to repeat myself. I'm going to say a lot of the things on this video that I said on the last video, but I really want to because a lot of this stuff, I think I'm going to attempt to put it in a little bit better flow than I did on the last video. But I'm going to repeat a lot of the last video, and also to help it kind of settle in a little bit. Let's see. One thing I wanted to notice. In a lot of courts, you'll notice that, like when you go into court, in a lot of places, a lot of government buildings, but specifically in courthouses, you'll notice that a lot of courts refuse recording devices. Now they come up with some crap as to, some kind of stuff for the media, some disinformation as to why they don't want recording devices in the courtroom. But a lot of that is to hide their crimes. They really are committing crimes in those courtrooms by incarcerating people and fining people for unconstitutional laws. And to me, that's just a simple crime. To me, they're criminals for fleecing America like they do. And they use scare tactics and lies and all kinds of stuff to manipulate people to plead out cases. They'll hold you in jail and basically force you to plead out. They'll have people that are trying to prepare for trial locked up with people that are already sentenced, which is a very good issue to raise for grounds. That's actually grounds for dismissal. Is that you're a pretrial detainee if you're incarcerated prior to going to court. You want to definitely raise that issue. But I'm a pretrial detainee here, and I'm locked up with people that are already sentenced. And these people that are already sentenced don't have anything to lose. And how in the world am I supposed to prepare for court when I'm locked up with all these convicted felons and misdemeanors? I mean, I'm locked up with all these convicted felons. How am I supposed to prepare for court? So you want to raise these issues, and you want to raise these not only verbally but also in writing in the court. But how can someone who is innocent hope to prepare for court when they're locked up with a bunch of convicted felons on their way to prison? They do that on purpose to make their numbers look good for elections. It's very simple. They lock you down. and they try and intimidate you into pleading out. They make your life miserable until you plead out. The legal argument is, I'm going to go over again a little bit, one more time here with you, about malum in se and malum prohibita, and the nature and the cause of the accusation. The government really doesn't have any lawful jurisdiction over us. Now, if we commit a crime where we injure somebody else's person or property in some way, then that's a crime, and we should be punished for that crime. And I think that those crimes actually should be punished more than what they are actually punished now. I think that will actually go a lot. I'm not trying to get all the criminals out of jail here with these videos. What I'm trying to do is I'm trying to put all the real criminals, the violent offenders and stuff, in jail and keep them there. A lot of reasons why for example, a lot of the reason why a lot of, for example, rapists, or at least what I hear, a lot of women don't go after, say, rapists or abusive husbands and stuff, is because they're afraid that they're going to get out of jail and come after them. Well, that's because the way the law is set up is that they are going to be able to get out of jail after a few years and track them down. Well, see, those are actually violent people that actually we need to get off the street. But the system isn't set up to really rid the United States of crime. The system is set up to make money by the head. The more laws that they can come up with, they make more money the more people that are in jail, because each person is tried, so they get paid more because they can, they have to pay, they charge us, the taxpayer, for each individual case and each individual person. Well, if there's fewer cases, they can't really charge they don't make as much money. Also, there's more money in confiscation, when they're able to confiscate stuff from like drug dealers and stuff, because they're able to keep all the proceeds from the drug sales and stuff. So that's why they focus in on all that and don't really, they do, now don't get me wrong, they do chase down killers and murderers and stuff, but it's only 50-50 now, and it needs to be 100%. About more on the issue of jurisdiction. I want to explain this issue a little bit more in depth on this video. A jurisdiction, a lot of times people will deliberately confuse the word jurisdiction with venue. Venue is the geographical location of where you are, where the crime, for example, where the crime was committed. Like, you can ask for a change of venue if you feel that you can't get which is a change of geographical location if you feel that you can't get a fair trial where you are, because everybody already knows you, or everybody knows about the crime or something like that. You can request a change of venue. So the venue is geographical location. Jurisdiction is a lot more. Having jurisdiction isn't the geographical location. Jurisdiction is much more complex than that. There's two different forms of jurisdiction. There's in personam jurisdiction, which is jurisdiction over the person. And I said earlier about the 14th Amendment. Let me give you a little bit why the courts claim to have jurisdiction over us. Now everything might start coming together a little bit for you guys, because now I'm going to begin to piece things together. What happened was, prior to the 14th Amendment, the citizens were there were black citizens actually too, but for the most part, the citizens of the United States were separate from the slaves. And what happened was, slavery was abolished. And then right afterwards, they passed the 14th Amendment to the Constitution. Now, the 14th Amendment states, all persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens, and those are small c citizens. Now, prior, if you look at a real Constitution, you'll notice that prior to that, citizens was always capitalized, and persons were always capitalized prior to that. So what the 14th Amendment actually did is it didn't really, it gave the newly freed slaves, it gave them second-class citizenship status. It gave them the privileges of due process, actually. It gave them, no state shall pass any laws to prohibit the privileges thereof. So it basically created a second-class citizenship. And after the Federal Reserve, um, um, uh, after the Federal Reserve bankrupted the country in 1929, they passed the Social Security Act. And that's when everybody signed up for Social Security. And when you sign up for Social Security, you sign that you are a citizen. You check the box saying you are a citizen, which is a small c in law. And so everybody kind of voluntarily signed up. When they sign up for Social Security is your contract. You sign a contract stating that you are a citizen subject. And again, if you look up the word subject in a Black's Law Dictionary, you will see that citizens subject is a slave. And prior to that, a citizen was defined by the Immigration and Naturalization Act of 1792. That's what defined a citizen, and that's what all these people were prior to the passing of the 14th Amendment. After the passing of the 14th Amendment, it gave black people second-class citizenship status, and then through the course of time, everybody just kind of voluntarily signed up to be citizens, as defined by the 14th Amendment to the Constitution. So we basically signed up to be slaves. And so when you're in court, a lot with the common lawyers and with the sovereigns and everybody else is arguing, what they're arguing is in personam jurisdiction, which means does the court really have jurisdiction over the person? And the thing is that really you can rescind any contract for lack of informed consent. In other words, you can rescind your Social Security number for lack of informed consent. You can basically say to the court, well, I had no idea that by signing this, by taking this Social Security number that I was giving up my citizenship status and becoming a second-class citizen as defined by the 14th Amendment to the Constitution. I had no idea that I was doing that. And so you can rescind that contract for lack of informed consent. And a lot of the common lawyers and people were actually doing that. They were arguing in personam jurisdiction, and they were basically saying that, this court doesn't have any jurisdiction over me. Now, the thing is that if you actually committed a real crime, like say murder or something like that, then the court has a victim and an injury, and you should be punished for that. And raising in personam jurisdiction or subject matter jurisdiction in that case is not going to work. But they can work very well and very effectively in mala prohibita cases where there's no actual, they can claim that the state is the victim all they want, but the truth is that the state really doesn't have any injury at all, and they can't produce any kind of an injury. And what's happened, actually, when you're saying, when you're asking, what's the state's, what's the state's injury? What the state's real injury is the fact that you are subject to that law, and you did not, you've signed the contract to agree to abide by that law by taking on a Social Security number and agreeing to be a 14th Amendment citizen subject. So that's where you consented. That's essentially where you've consented to this law. And so really the point I was getting at is that, even actually, if you want to know the truth, the mala in se law that I'm talking about right now, actually, if you want to know the truth, the real victim, even in the mala in se case, let's say I go out and I kill you, that's actually, by law, that's actually not really a mala in se case, because it's actually mala prohibited, because actually what I did is the state's actually the victim, because you're a state slave, and because I killed their property, which is state property, because I damaged another slave, the state actually is claiming to be the victim in that case too, by the way. These cases that I'm saying are mala in se technically are actually mala prohibita, even when there's an actual injured victim, because what I've really damaged is that I've damaged state property, being you. So, but if you don't know that, they're not going to certainly tell you this. and they hide this stuff, and they hide this stuff very well. And if you know if you know that, then you know a lot more about how to handle this in the court, because really all the cases are actually malum prohibita, because everybody is actually state property. You are a citizen subject. A subject. If you're subject, you're a slave. You're a state slave. And and if I hurt you, I've damaged state property. So it's actually malum prohibita. But they don't want you to know this. Hope I'm not confusing you, but that's what's going on. And so there's in personam jurisdiction, which is jurisdiction over the person, and that's how they've got in personam jurisdiction over you, is through, well, not just your Social Security number, but just any ties that you have at the state. Any tie that you have, the Social Security number being the big bad guy that everybody kind of signed up with during the Great Depression. But after then, it was, now, driver's licenses, all these different licenses and stuff, it all, you check the box saying that you're a citizen of the United States and stuff like that. So you've signed up to be a citizen subject. And, let's see. For example, to give you an example of somebody that's free of in personam jurisdiction. They have jurisdiction over you, but you've noticed, like, certain foreign diplomats, like, you've ever heard of diplomatic immunity? Somebody that's, somebody coming over, and that person's on American soil, but they have diplomatic immunity. Now, the reason why they have diplomatic immunity is in personam jurisdiction. The court doesn't have jurisdiction over them. They don't have a Social Security number. They don't have any. They don't have any jurisdiction over that person. So diplomatic immunity is a perfect example of somebody that the court doesn't have in personam jurisdiction over. So that's in personam jurisdiction, and you can challenge that, but it's very passive, because you don't you can raise the issue in court, but they're not. It's not as effective as subject matter, because subject matter you can actually force them to ask questions. The subject matter is where you can ask them questions and get it on the record of them not being able to show your proof of consent to abide by this law. So to go a little bit more into how this thing is argued, again, the judge is always going to ask you, because they want to, they want to make sure that they always ask you, do you understand the charges against you? And again, that's probably one of the best times to ask. To raise, well, I demand my Sixth Amendment right to be informed of the nature and the cause of the accusation. Is this malum in se or malum prohibita? And let's say the prosecuting attorney says, well, it's malum prohibita. You obstructed government process. It's obstruction. and you say, well, what is the okay? So it's malum prohibita. Well, who did I injure? Well, you injured the state. Okay. Well, what is the state's injury? What is the state's injury? And really, they could say, well, you've wasted government's time. You've obstructed our process. Well, that would be more of a civil case than a criminal case. If they do try and take that angle with you, why am I in criminal? Well, that doesn't sound like a criminal, because if you've lost some time off work due to my damage, then why am I? This doesn't sound like a criminal proceedings. This sounds like a civil proceedings where I wasted the government's time. If I wasted the government's time and you've lost man hours, then you should be suing me civilly for the money that you've lost. Not charged. This isn't a criminal offense. This is a civil offense. At best, obstruction would be a civil offense. And they want to make it criminal. You've wasted the government's time. They want to make that criminal for you to waste the government's time. And but they don't have any real damage. And so the injury is probably really the number one thing. The nature is either malum in se or malum prohibita, and the cause is who you injured, and most importantly is how you injured them. Is really the number one thing. Let's see. Again, I told you about I told you about that. I do want to say the courts, by the way, do not want you to know and use this stuff. And just as I was warned, I'm going to warn you too that if you're going to fight for your freedom and righteousness, be prepared to suffer a lot. Courts will they'll strike back. But I think a lot of you guys are at your wits' end, and I think you're ready for that because you're doing it already. You're just doing it the wrong way. But if you're gonna stand up for yourself, be prepared. You know they're gonna cheat. They're drug dealers. Remember that. they're gonna do whatever it takes. Okay, so the information. So they give you the information or the indictment or the complaint. The information is state. The indictment is federal, and a complaint is back in the old days, back when things were normal, probably the way they should be now. But they give you this, and they tell you what you did and who you did it to. And technically, the government actually is still the victim in all these cases because you hurt state property. I want to point that out again. You hurt another citizen, which is state property in some way. So, but that's just something to tuck away for later. I'll get more into that a little bit later. But in cases of a mala prohibita, the information does fail to charge an offense. This is not just, it doesn't specifically state, even if it does, you know, it says, okay, the state's the victim, but it doesn't tell you how you injured them. It's really pointless to argue subject matter jurisdiction in a Malamanze case, though, when there's a real victim. If you're actually going to court, they have an actual victim. I would be hesitant to raise this because they actually do have a regular victim, even though the state is still claiming that you damaged state property. You've actually done a crime. If you kidnap somebody, you know, this argument is not going to work as effectively, obviously, than if you're just, you know, occupying someplace. You know. As far as the occupying someplace, they could bring in a victim in that case, which would be possibly the business owners. But that still would be it would probably be a civil matter where they've lost business because of you, and they could sue you civilly. As far as it being criminal is questionable. Maybe, you know, that would be the judge. It sounds to me like a civil matter if you're occupying businesses. Again, I think that occupying businesses is a waste of time. We need to be if we're going to occupy something, we should be occupying the government. And actually, we should be personally, I think there's enough people that are upset that I really think that we could actually turn this into a political movement if I could get these camps together and I'd like to see these camps get together a lot. The issue of jurisdiction can be raised at any time. Raise it right away if you want to. I always write it out. In fact, back in the day when I was involved in this heavily, I always had a fill-in-the-blank habeas corpus in my back pocket at all times. So when the cops would pull me over, I just fill, okay, officer so-and-so, and had him a habeas corpus. And I'm going to get into habeas corpus probably on this video too a little bit. Habeas corpus means you have the body. I've been getting ahead of myself again, but okay. So it's also very important that when you go into a court that you request that a record be made of the proceedings. Most of the time, they are making a record of it these days. You request a record being made, and if they're not making a record, like if it's a traffic violation, they'll say, "Well, this is just traffic. We don't need." Well, you know, I demand, you know, and then okay, I save that issue save it for appeal. If they deny you something, that's okay. Just say, "Well, I save that issue for appeal." You know, always say, "Okay, I want to." You know, raise everything, demand everything you can, because if you don't raise it, you waive it. So you want to raise up everything that you possibly can. And in court, they've tried to bully me and stuff, and like, you know, well, and I'm in there on kind of serious charges, and they don't want to make a record of what's going on because they know what kind of guy I am. And so, well, I demand the names and addresses of every person in this courtroom to call as potential witnesses to these proceedings. You really got to be firm with them. If they demand the names and addresses of all witnesses, it's a good idea. It's always a good idea that if you're going to be going to court, to be in a group of people on your side on the courtroom, taking notes on everything that is said, or if this happens to be a courtroom where you can record it, all the better. And nowadays we have such badass recording devices. If you can sneak a recording device in there, that'd be just great. Record these criminals, because it's really what they're doing. They're just ripping us off. This will do a lot. Actually, just having a group of about 3 people there, just writing down everything that's said, will do a lot to get the judge on your side. What you're doing here is you're getting the judge on your side. By now the judge is a lot of times they'll pretend to be pissed, but if you let them intimidate you, they won, and they will try. This is really what separates handling a court case is really what separates the men from the boys. It's it's one thing to fight for freedom in a group of people when you're armed in tanks and guns and stuff like that. It's entirely different to stand up to a judge. And those of you that do stand up to the cops and to the judges and stuff like that, I tip my hat to you, because I've been there, and it's not easy, because these people they can be really heavy-handed. So you demand your right to be informed of the nature and the cause of the accusation as defined by Amendment 6 of the U.S. Constitution. And if you're in it for a state case, you might want to look up it's usually the same thing in the state Constitution too, the same amendment, and the Constitution of whatever state that you happen to be in. There's actually a certain time limit. Most states have a certain time limit in which you must receive an information. And if they go over this time limit, like for example, I think in Missouri, if they fail to give it to you for every 6 or 8 hours that they go over, you can sue them for $500 in the small claims court. And this is like a law. And so as long as they're refusing to give you a valid information or complaint, and they'll give you the information, but it fails to charge an offense. So if they've given you a bogus information here that doesn't charge any kind of offense, and you can start racking up the $500, and you let them know, you send them, say, it's been 24 hours, you haven't given me a valid information, that's $500, that's $1,500, and you go ahead and start a small claim suit against them right then. I've done this right out of the jail cell. Let them know that you have to give me a valid information, and you have to, you might want to really familiarize yourself with the law if you're going to try and do all this, because there's a lot that you have to know. If it's a federal case, it'll be an indictment, and again, there's a time limit that they have to give you the indictment. But if the crime is a malprohibited crime, undoubtedly it will be flawed. And you want to state to the court that this I always call it a pretend information. It's a pretend information or indictment. It fails to charge an offense. It does not specifically state who I injured and how I injured him. And at this point, the prosecutor will come back with an argument like the state is the victim and you broke the law. I would, at that point, well, where's proof of my consent to obey this law? And he'll say something like, well, are you a U.S. citizen? And I would say something like, are you referring to a U.S. citizen as defined by the 14th Amendment, or are you defined to a U.S. citizen as defined by the Immigration and Naturalization Act of 1792? And let him answer that. And then when he doesn't answer that, if he says 14th Amendment, you basically got him. Well, where's the proof of the contract? Where did I sign the contract? And I seriously doubt that prosecuting attorney is going to say, well, it's your Social Security number. If he does, it'd be like, oh, so my Social Security, well, then I rescind that contract for lack of informed consent. I had no idea that by taking that Social Security number that I was agreeing to abide by all these silly little rules and regulations that you people can come up with. You see, that's why I told you about that in the beginning. And I know this might be a little bit hard to swallow for a lot of you, but it's true. And that's how it is. And but inevitably they're going to get pissed because they don't want to tell you what contract you signed, which is your Social Security number. They're not going to want to tell you what contract you signed that made you agree to abide by all these little rules and regulations, and you can so they didn't therefore they don't establish subject matter jurisdiction in the case, which makes it against the 6th Amendment to the Constitution. They did not establish they never showed any cause. They did not show an injury. They did not show the cause, which is who you injured and how you injured them, most importantly. They did not show any kind of an injury, like, for example, having a plant in your pocket. They weren't able to show any kind of a valid injury. Therefore, if they continue to hear the case, if a judge and a prosecuting attorney continues to prosecute a case when they do not have jurisdiction, they have waived their immunity. and they do open themselves up to suit. And there's all kinds of case law about that that I don't have anymore because all my stuff was stolen by government, by the way. A lot of my notes and stuff was stolen a long time ago. But you can look this stuff up in the law book, and it's true. That's it. They open themselves up to suit. And you can tell them that I can't believe, you can bring it up in court. I can't believe that you guys are going to continue to hear this case when you haven't established subject matter jurisdiction, and just save it for appeal and just raise all the arguments that you can. And even really the strongest argument, though, is the injury. Demand to be informed of this. Well, the prosecutor says, well, the state's the victim. Well, what is the state's injury? And all these mala prohibita laws, I'm talking about, these are victimless crimes. And like, for example, there might be mala prohibita crime, such as loitering in front of a business. That would be more of a civil case. But dealing with a minor civil case is better than going to jail. Because then the store owner is the victim in that case. Well, again, the state is actually claiming to be the victim because you damaged one of their slaves. But the victim that they're going to put on the information to kind of cloud the issue would be the store owner. And then if the store owners these store owners that you're loitering out in front of, they're not in the courtroom. If the prosecutor says, well, the store owners, the businesses were the victims because you were loitering in front of their business and damaging their business. Well, why isn't the business owner here? Don't I have a right to to confront the witnesses and evidence against me? And why isn't the business owner listed on this? And more importantly than that, why isn't the business owner listed as a victim on this pretend information? That's the key thing there. Let me say that again. If they say, well, the businesses are the victim, you were loitering in front of these businesses, you were hurting their business. Well, why isn't the business owner listed as a victim on this information? On this pretend information is what we used to say a lot of. We call them pretend informations because we didn't want to give them benefit of the doubt that their information was anything other than crap. So we call them pretend informations. Remember, you do have the right to confront the witnesses and evidence against you. And at this point, they're going to get pissed. Some really dumb ones will come back with, the 14th Amendment, but you can simply state that you're a citizen as defined by the 1719, or the Immigration and Naturalization Act of 1792, and therefore no court has jurisdiction. The court doesn't have jurisdiction over the subject matter. Removed or dismissed for lack of jurisdiction. Enter all this into writing. You demand a right, you petition for a writ, and you motion for pretty much everything else. Jurisdiction is the most powerful argument you can raise. Again, the judge has judicial immunity in all cases he has jurisdiction over. The judge has jurisdiction in two cases. If a judge is acting in his judicial capacity, in other words, the judge he has immunity from prosecution, whether civilly or criminally, if he's acting in his judicial capacity. In other words, if a judge is off not working and he goes out and murders a whole bunch of people, he doesn't have immunity from that. He only has immunity as long as he's in his judge role. So he has to be in his judicial capacity, and he has to have jurisdiction over the case. If he doesn't have jurisdiction over the case, he does not have immunity. Okay, he has to be working in this jurisdiction. Jurisdiction is that important, and so that means that if he establishes jurisdiction in the case, he can't be sued. But if you raise the issue of jurisdiction and the judge refuses to establish it, and I have before many, many times, Judge, I cannot believe you're going to waive your judicial immunity and open yourself up to civil suit by not establishing, or criminal charges, actually. If you suffer a lot of, if you go to prison, it's criminal charges. Because all the damage that you think by not establishing subject matter jurisdiction. And be sure to save the issue for appeal. Because chances are 100% that they're going to go ahead and continue even though you've raised this issue. So don't be surprised when they just ignore you. And don't get too mad about it because that's what they're going to do. They're not going to say, okay, you got us, this is not really a crime. They're not going to do that. What they're going to do is they're going to go, we got to figure out some other way to get rid of this guy. In most cases. Nowadays, it's a totally different ballgame. But back in the 90s, that's what they would do. But really, back in the 90s, the whole tone of the court would change. In most cases, the next time when we would go to court, the judge was our buddy. The judge was a buddy. He was looking for any reason to get this case out from underneath them. He's got this huge line of people here that he can, slam dunk, and the last thing he wants to do is fuck with somebody that's going to sue him. So we raised every single issue that we could. Now, maybe this wasn't such a good idea if our plan was to set precedents on this issue. But we were helping a lot of people. It was in the early stages of working these issues out, and we were really the guy that mentored me through all this. His main issue was the Second Amendment. He's big time Second Amendment, which is another issue that's malprohibitive. The Second Amendment, your right to bear arms is the Second Amendment. That was the issue he was raising. How did he, by possessing, who's the victim? Okay, well, you possessed a firearm. Okay, that's another one of these possession things. Remember the possession thing? You possessed a firearm. This is his big thing, was the right to bear arms. And I know a lot of you guys are going to want to get behind that. And that was the issue he was raising. And he was raising subject matter jurisdiction. He was also raising religious reasons too. He was raising not just his Second Amendment rights, but also religious and all kinds of other badass arguments. And we worked together for quite a while. The Second Amendment is another thing where, if you take a gun, you go shoot somebody, there's a victim. But if you're just carrying a gun around, there's no victim. There's no victim. And that's really probably one of the number one issues that this thing is really all about. Not just another malprohibited crime. So let's see. If you're going to do this, be sure to have all this information committed to memory, because they will try and trip you up. The bailiff is going to try and intimidate you. They're not going to play fair. If we could get 1 million people to do this all at the same time, this would jam up the court system, and it would actually force them to take us seriously while they argued jurisdiction with several million people at once. And really all we'd be doing is just be simply asking for constitutional rights here. Remember, this isn't some kind of movement to try and damage. I'm not trying to damage stuff here. A lot of people will think, okay, he wants to fuck everything up. No, what I'm trying to do is I'm trying to fix things, because we do have a Second Amendment right, and it's worth fighting for. So the constitutional right to be informed of the cause of the accusation, and so that those are the things. Is you do have a right to be informed of the cause of the accusation, and stating and remember to state that the pretended information just simply does not charge an offense. Now, be warned that these people are filthy corrupt. Let me see how much time I am on this one already. Okay, I'm already at almost 40 minutes on this one. So I'm going to go ahead and see how it came off, and I'm going to stop. I'm going to put a little note here. This is where I stop. And thanks a lot for listening.